Luke, this is your reporting. You mentioned this, you flagged this for us just as it was breaking. We have you back today because you've written sort of the definitive piece of reporting on this. Take me through what Judge Carter is saying.
Yeah, it really is an extraordinary opinion by the judge here. We knew that Judge Carter several months ago felt that Donald Trump and John Eastman had committed, well, more likely than not, had committed 2 federal felonies: obstruction of official proceeding of Congress and conspiracy to defraud the United States. And what he said yesterday in this ruling is that specific emails from John Eastman that had not yet been turned over to the January 6th committee is more evidence of one of those crimes. Specifically, there's one email that he honed in on where John Eastman is going through some of the data, where they're going through deceased voters and unregistered voters. And he's saying, guys, the stuff we put in our lawsuit is not accurate. And we've been told it's false. And the president knows it's false. So I'm advising that President Trump not sign a verification document attesting that this is true. And what does Donald Trump do? He signs the document and they file the suit. And Judge Carter is saying that is evidence of a crime. And so I think now these emails will go to the January 6th committee. They'll be able to use it for their investigation. But also these emails can be used by prosecutors both in Georgia and federal prosecutors if they so choose.
Andrew Weissmann, I want to read more from the ruling, and I'll save my question until after I do that. On December 4th, 2020, President Trump and his attorneys alleged in a Georgia state court action that Fulton County improperly counted a number of votes, including 10,315 deceased people, 2,560 felons, and 2,423 unregistered voters. On December 30th, 2020, Eastman relayed concerns from Trump's team about including specific numbers in the paragraph dealing with felons, deceased, moved, etc. As Eastman explained the next day, although the president signed a verification for the state court filing back on December 1st, he has since been made aware that some of the allegations and evidence proffered by the experts has been inaccurate. For him to sign a new verification with that knowledge and incorporate by reference would not be accurate. Trump signed a verification swearing under oath that the incorporated inaccurate numbers, quote, are true and correct, or believed to be true and correct to the best of his knowledge and belief. What does it mean now that we have crossed over to this point where a federal judge is alleging criminal behavior on the part of Donald Trump? Does that satisfy probable cause and take the investigation to a new place?
Well, I think it's great that you started there, because one thing that I find myself getting inured to is the idea that a federal judge has found that a former president of the United States has committed obstruction of justice and fraud by the standard of more likely than not. But it still is a remarkable finding. The federal and state prosecutors obviously need to wait to see what the documents actually say and whether they bear out exactly what Judge Carter found. But they do 2 things. One, it makes it very hard for Donald Trump, if he's charged, to say that he relied on the advice of counsel. In fact, he's doing the exact opposite, which is he has counsel saying, don't do this, the numbers are inaccurate. And then he went ahead, as Luke said, and signed anyway. And it fits very much with the entire theory of the evidence that we've seen in the January 6th committee, which is Donald Trump publicly presenting himself as if he won the election and saying a whole series of falsehoods, but privately being told by the attorney general, by his campaign manager, that he lost the election. Well, here you have his own counsel again, here in John Eastman, saying that what you are about to represent publicly, and this time to a court, is inaccurate. So this is going to be more proof that can be used at both at the federal and state level.
Andrew Weissmann, I cannot go back in time to the Georgia efforts without doing two things, playing the Raffensperger call and reminding everybody about the human collateral of Trump's lies, Shaye Moss and Ruby Freeman. I mean, if they had a civil legal pursuit against Donald Trump, does this satisfy the preponderance of evidence burden in any of those potential legal endeavors if you've got a federal judge meeting that standard by saying more likely than not crimes have been committed?
Well, the answer is yes, but the judge's finding that you can't just take the finding and introduce it into a criminal case or a civil case. But the evidence that is about to be produced is something that you can use. And of course, if there were a civil proceeding, the standard is exactly the same. So assuming you had a state court judge or a state jury making a finding that civil liability, if they applied the exact same standard as Judge Carter, you would presumably get the exact same result. And there would be more evidence than what was before Judge Carter, because he is actually looking at a sliver of the evidence that the January 6th committee and the Georgia prosecutor is looking at. And it's worth remembering also that Rudy Giuliani is alleged to have made exactly these representations to the Georgia legislature that Judge Carter is saying were actually false, and that the team internally knew it was false. So this is also, I think, a pretty bad day for Mr. Giuliani.